You're driving home. Windows down, music low, mind at ease. It was a good night. Maybe dinner with friends, maybe just a late drive to clear your head. And then it happens. Red and blue lights erupt in your rearview mirror. Your stomach drops. Your hands tighten on the wheel. And the most dangerous thought enters your mind. I didn't do anything wrong. I have nothing to hide. I'll just be honest. That thought, right there, is exactly what they're counting on. My name is Theodore Walton. I spent years inside the prosecutor's office. I built cases. I watched them fall apart. I saw exactly how and why people got arrested, searched, and charged, often for things that never should have gone that far. And the one thing I kept seeing, over and over again, was this. People weren't losing because they were guilty. They were losing because they didn't know the rules of the game they were already playing the moment those lights came on. So today, I'm going to give you what most people never get. A look inside the exact playbook police use during traffic stops. 5 specific tactics: psychological, legal, and physical. And more importantly, I'm going to tell you exactly what to do in each situation so you walk away, not in handcuffs, not in a patrol car, just home. Now, before we get into it, I want you to hold something in your mind the entire time you watch this. A traffic stop is not a conversation. It is not a courtesy exchange. The moment those lights came on, an investigation began. And everything, every word, every movement, every second of silence is evidence. Once you understand that, everything I'm about to tell you will make perfect sense. Let's talk about the first thing cops do, and it starts before you've said a single word. The officer steps out of the cruiser. He adjusts his belt, takes his time walking to your window. You're nervous. You're already rehearsing what you're going to say. And when he gets to your window, he doesn't open with license and registration. He opens with something like, "Hey, how's your night going?" Or, "Where are you headed tonight?" Or, "You been out having some fun?" This is not small talk. I know it feels like small talk. It's designed to feel like small talk. Police officers are specifically trained in what's called a pretext conversation, a casual-sounding exchange engineered to get you talking, so that anything you reveal can be used as probable cause to escalate the stop. You have to understand, that officer does not care where you're going. He doesn't care how your night was. He's listening for inconsistencies. He's watching your eyes. He's smelling your breath. He's building a file on you in real time, right there on the side of the road, and you are handing him the material. Here's what makes this so dangerous. You are not being interrogated in the legal sense at this moment. Not yet. Most people think their Miranda rights protect them from the moment police start asking questions. They don't. Your Miranda rights remain silent without that silence being used against you, only kick in when 2 things are true at the same time. You are in custody, meaning you're not free to leave, and you are being actively interrogated. On the side of the road, during a routine stop, you are technically not yet in custody, which means everything you volunteer flows freely into the investigation, and no one is legally required to tell you that. So when the officer leans in and asks where you've been, and you say, "Just had dinner with some friends, had a couple drinks, nothing crazy," you just handed him the key to a DWI investigation. That phrase, "a couple drinks," is almost a guaranteed trigger. It doesn't matter that you feel perfectly fine. The moment alcohol enters the conversation, the entire nature of that stop shifts. Now, some officers won't use friendliness. Some will use the opposite. They'll come to your window with an attitude, sharp, dismissive, maybe borderline aggressive. They'll make you feel like you've already done something wrong, like you owe them an explanation. And this is calculated too, because frustration makes people talk. Frustration makes people justify themselves. And the moment you start justifying yourself, you're giving them something to work with. The answer to both of these, the friendly version and the hostile version, is the same. You don't engage. You remain polite, you stay calm, and you say as little as humanly possible. Hand over your license and registration. Keep your hands visible, and do not fill the silence. Silence is your first line of defense. But here's where it gets complicated. And this is the part most people don't know. And it's the part that genuinely floors people when they hear it. Staying silent is not enough. In fact, if you simply go quiet and refuse to answer, that silence can be turned against you in court. I'm not saying that to scare you. I'm saying it because it's settled law. In Salinas versus Texas and Berghaus versus Tompkins, the Supreme Court ruled that the right to remain silent is not automatic. It is not self-executing. If you want your silence to be protected, you have to say so out loud. Read that again. To protect your right to say nothing, you have to say something first. The exact moment an officer starts pressing you with questions, specific, direct questions, you need to clearly and calmly state, "Officer, I am invoking my right to remain silent." 7 words. And then you stop. You don't explain it. You don't apologize for it. You don't soften it by adding, "I'm not trying to be difficult." Because the moment you do that, you started talking again. 7 words, and then nothing. What happens after that? The officer may try to pressure you. He may act offended. He may tell you that your silence makes you look guilty. None of that is legally meaningful. What matters is that you said those words, and everything that comes after, every attempt to break you, every question, every little psychological nudge, is now subject to challenge if this ever goes anywhere. Now let's talk about what your body is doing while your mouth is staying quiet. Because here's something most people never consider. You can say all the right things and still give the officer exactly what he needs. When a police car pulls you over, there are almost always 2 officers involved. The primary officer coming to your driver's window, and a secondary officer who hangs back, circles, and watches the passenger side. And what are they watching for? Movement. If you reach toward your glove compartment, that's a flag. If you lean over to the center console, that's a flag. If you turn to look toward the back seat, that's a flag. These movements, regardless of what you're actually doing, can be cited as evidence that you were attempting to conceal something or access a weapon. And that gives them the legal footing to remove you from the vehicle, pat you down, and if they're creative with their language, start pushing toward a search. This isn't theoretical. Under Pennsylvania versus Mims, police can order you out of a vehicle during a lawful stop. They don't need much of a reason. Officer safety is a phrase so broad in practice that courts have allowed it to cover almost anything. A sudden reach, a shift in posture, a change in your demeanor, all of it can be retrofitted into justification. So here's what you do. Before the officer even reaches your window, have your license and registration already in your hand or on the seat beside you, not in the glove box, not in the center console. Keep your hands on the steering wheel at the 10 and 2 position, visible, still. Do not move unless you have to, and if you have to move, if the officer asks for something that requires you to reach, you say exactly what you're about to do before you do it. I need to reach into my back pocket for my wallet. And then you move slowly, deliberately. You announce, and then you act. Never the other way around. This sounds overly cautious, I know. But I have seen situations escalate from 0 to catastrophic in under 30 seconds because someone made a completely innocent movement that an officer decided to interpret as threatening. The benefit of the doubt is not guaranteed in these encounters, so don't leave your safety up to chance. Now we've covered what you say and what you do. But there's a moment in almost every traffic stop where the conversation shifts, where the officer stops with the questions and moves to the ask. Mind if I take a look in your car? Or sometimes it's softer. You don't have anything in there I need to know about, do you? Or sometimes it comes dressed up as logic. If you've got nothing to hide, this should be no problem, right? This is arguably the most dangerous moment of the entire encounter, because this is where good intentions get people arrested. You have an absolute constitutional right to refuse a search of your vehicle. Fourth Amendment. It is not suspicious to refuse. It is not an admission of guilt to refuse. It is the exercise of a right that exists specifically for this moment. And when you refuse, and you should always refuse, you say it simply, "I do not consent to a search." Not, "I'd rather you didn't." Not, "I don't think that's necessary." I do not consent to a search. Clean, clear, on the record. Now, once you say that, the pressure doesn't disappear. In fact, it often intensifies. The officer may tell you he'll just get a warrant. He may tell you it'll be faster and easier if you cooperate. He may tell you that refusing makes you look guilty. And this is where people cave, because standing firm in the face of authority feels uncomfortable. It feels like you're doing something wrong. You are not. Saying no to a search puts the burden exactly where it belongs, on the police. To search your vehicle without your consent, without a warrant, they have to satisfy what's called the motor vehicle exception, and it has real requirements. They need probable cause, not a hunch, not a feeling, but articulable facts suggesting criminal activity is occurring. They need to be in a location that is not the curtilage of your property. The vehicle needs to appear mobile, and their search has to be limited to areas where whatever they claim to be looking for could logically be found. You cannot say you're looking for a rifle and then search a matchbox. When you consent, all of that goes away. Consent is a legal key that unlocks everything. I have seen officers tear the interior of a car completely apart. Seats pulled, panels removed, personal belongings scattered across a highway shoulder. And when they didn't find what they were looking for, they left. Just turned around and walked back to their cruiser. Left the person standing there surrounded by the wreckage of their own vehicle. Because consent was given. Because the person thought they had nothing to hide and didn't want to seem difficult. Never consent to a search. Not because you're hiding something, because your constitutional rights are not a performance you only use when you're guilty. They're protections that exist every time, for everyone, and using them is the correct thing to do. Now here's where things get interesting, because sometimes officers know they can't meet those requirements, and they have a backup plan. And if you don't know about it, it can completely undo everything we've talked about. The threat of the drug dog. You're standing on the side of the road. The officer can feel you're not going to consent. He's been polite, he's been firm, he's been slightly intimidating, and you've held the line. And then he says, "Fine, I'll call for a K-9 unit. You can wait right here." Most people in this situation either panic and consent, which is exactly what the officer wants, or they think, "Fine, call the dog. I have nothing to be afraid of." Both reactions are the wrong ones, for different reasons. Let's start with the waiting. In Rodriguez versus United States, the Supreme Court drew a very specific line. Once the basis of the traffic stop has been resolved, meaning the officer has written the ticket or issued the warning that justified the stop is over. The officer's authority ends at that moment. He cannot extend the stop to wait for a drug dog. He cannot ask you to wait around. He cannot use the delay as leverage unless he has independent reasonable suspicion of a separate crime. And if he violates that rule, any evidence gathered from that extended stop is potentially suppressible in court. So what do? You record the encounter from the moment those lights came on, if you legally can. You calmly and repeatedly ask, "Am I free to go?" Every time he stalls, every time he deflects, you say it again. "Am I free to go?" If the answer is no, you are being detained, which means you are now in custody, and the clock has started on what he can legally do. You don't run, you don't argue, you just document and keep asking. And about those drug dogs, I want you to understand something that the criminal justice system does not advertise. Drug dogs are not infallible detection machines. They are animals whose behavior is interpreted by their handlers, who are human beings with their own perceptions and biases. The Fourth Circuit Court of Appeals has acknowledged cases where drug dog reliability was as low as 43%. 43%. That means in some circumstances, a dog alerting on your vehicle is barely better than a coin flip. And the Supreme Court in Florida versus Harris said that even a dog not trained on a specific substance can still provide valid probable cause if the court is satisfied the dog is reliable. Reliable. Defined loosely, applied broadly. This is not a tool for justice. It is a tool for circumventing the protections you've been trying to use. So you do not consent to it. You do not agree to it. And you make it absolutely clear that you are not staying voluntarily. There's one more thing I want to cover, and it might be the most important of all. What happens if, despite everything, you end up in handcuffs? You did everything right. You stayed calm. You invoked your silence. You refused the search. You asked to leave, and the officer arrests you anyway. Maybe it's unlawful. Maybe it'll be thrown out later. But right now, the cuffs are going on. And this is the moment where people make their biggest, most irreversible mistake. They fight it. They pull back. They argue. They try to reason their way out of it in real time because the situation feels wrong and unjust, and it is. But none of that matters in the next 60 seconds. What matters in the next 60 seconds is this. Any physical resistance, any attempt to flee, any raised voice that an officer can characterize as threatening, that is a charge that will stick. Resisting arrest, evading detention, assault on a public servant. These are not difficult charges to prove. The bar is low and the officer's word carries enormous weight. The system has flaws. The encounter may be completely unjustified, but you cannot litigate that on the side of the road. You litigate it in a courtroom with an attorney, with the evidence you've preserved by staying calm, saying the right things, and not handing them anything new to work with. If you are arrested, you say 4 words. I want a lawyer. Not a sentence, not an explanation, not I want a lawyer because I didn't do anything. Just those 4 words. And then you stop talking, permanently, until you have counsel. Because anything you say in that patrol car, at that precinct, in any moment before your attorney is present, all of it is admissible. All of it is being used. Even the things you say trying to explain how innocent you are. Here's what I want you to take away from everything I've said today. A traffic stop is a legal encounter with rules, and most people walk into it blind. The officer knows the rules. He's been trained in them. He uses them every single shift. And the only equalizer you have is knowledge. Knowing what rights you have, knowing the exact words to use, knowing when to speak, and when to be absolutely, completely silent. You have a Fifth Amendment right to remain silent. You have a Sixth Amendment right to counsel. You have a Fourth Amendment right against unreasonable searches and seizures. These are not technicalities. They are not loopholes for criminals. They are your rights, built into the foundation of this country, specifically because history has shown, again and again, that power unchecked will overreach. My name is Theodore Walton. I have been on the other side of these cases. I have seen what happens when people know their rights and what happens when they don't. And the difference, the actual real-world difference in how those situations resolve, is not small. The next time those likes appear in your mirror, you will not panic. You will not talk your way into trouble. You will not let silence be twisted into guilt or a friendly conversation become a confession. You will know exactly what to do, and you will do it, because the goal is always the same: to make it home.